have Philip Morris versus Green. Between these two. We'll take a short break after this case.
Yeah,
We have the coffee set up. Yeah. And we can meet in the lawyer's lounge with the attorneys if you'd like to come in there for a few minutes.
That would be very nice, thank you.
And how much time would you like for a rebuttal?
Your Honor, I would like to reserve 5 minutes for rebuttal, please.
All right.
May it please the court, my name is Bill Garrity, and I represent the appellant in this case, Philip Morris USA. This case should be reversed and remanded for a new trial because the award of non-economic damages was excessive. The jury was motivated by passion and prejudice, and they disregarded the evidence in the case. And the excessiveness of the award, we believe, is demonstrated by 3 key points. First, the damages awarded were double the amount requested by plaintiff in his closing argument. Plaintiff's counsel specifically asked for $5 million, and the jury awarded $10 million. We've cited R.J. Reynolds Tobacco Company versus Webb, which stands for the proposition, among other things, that in and of itself is a strong indicator that the jury was motivated by passion and prejudice. And the court specifically said that although not determinative, the fact that the jury doubled the amount of compensatory damages requested by plaintiff's counsel, quote, suggests the jury was influenced by prejudice or passion. The jury's award of economic damages in this case clearly demonstrates that the jury went beyond the evidence in arriving at its verdict. The plaintiff's own experts in this case testified that Mr. Rizzuto had $1,132,000 in past and future medical expenses. Yet the jury went on to double that amount and awarded $2.55 million in economic damages. Now, the plaintiff subsequently stipulated to a remitter of the economic damages award, but that in and of itself is an implicit concession that the award was excessive and based on considerations outside the evidence.
Are you able to point to a particular thing in the record and say, here's what caused the prejudice, here's where the inflamed, passionate talk got them away from the evidence and the facts in the case?
Well, there's no issue about the plaintiff's counsel making any kind of inappropriate comments during closing arguments, so the answer to that is no. But the jury certainly heard a lot of testimony that would make them very sympathetic and empathetic toward Mr. Rizzuto, no question about that.
What's the ultimate standard for us to apply? I mean, you indicated that the fact that the jury awarded, twice as much as what was requested closing is an indication of an of inflamed passion, etc. But what's the ultimate standard that we apply?
Well, I think under 768.74 there's a series of factors. That statute makes it very clear that this court and the trial court should take any award and look at it under very strict scrutiny. So I think your honors can look at the award and determine based upon the evidence whether or not you think the award is excessive. So in other words, I think you can kind of...
Do we look at whether it shocks the judicial conscience? I think that's a...
Right. That is the language that you see in a number of the cases. Absolutely right.
Is that the bottom line for us to apply?
I think that is the bottom line for you to apply. If this award shocks the judicial conscience when you compare the size of the verdict to the evidence that the jury heard. And in this particular case, the evidence, the award bears no reasonable relationship to the actual damages proved in the injury that was suffered by Mr. Rizzuto.
You'd still be claiming the damages were excessive if it was $6.3 million, in other words, the $5 million. I'm not sure he said that's all we want. I think he said it would be, anything less than that would be appropriate.
Anything.
Give us $5 million. He said anything less. I see what you're saying there, but would you still be saying it was excessive if it was the $5 million figure plus the $1.3 million in the past and future medicals?
We would still be saying that that amount is excessive. I think anything above what the plaintiff's counsel asked for in this case, based on the record we have before us, is excessive. For example...
Is that what he asked for, $5 million plus the 1.3?
Well, the 1 point, I'm talking only about the non-economic damages. I guess I misunderstood Your Honor's question. I thought you were saying 6.3 in non-economic damages.
If the jury awarded $5 million non-economic and the 1.3 million economic, would you still be saying it's excessive?
I think that would be a much closer call, and that would be within the realm of, I think, what the jury could properly award in the case.
So is $7 million too much, $8 million? I mean, that's the problem we have, where, if it was $100 million, okay, but it's not, this is not the only $8, $10, $12 million case out there in this realm of litigation.
Well, but it's the only one involving a living smoker with COPD who had this type of unusually mild form of COPD. If you, Your Honor, obviously has looked at some of the verdicts that were cited by plaintiff in their case, we are talking about extreme examples of people who, in the Caton case, for example, she couldn't bathe, she couldn't dress herself, she couldn't leave the house without assistance.
Isn't the fact that the plaintiff in this particular case, the fact that he had mild COPD, isn't that a double-edged sword? Couldn't the jury have concluded that he's going to live a lot longer than those with more severe COPD, and that it's a progressive degenerative disease, and therefore he should be awarded greater pain and suffering damages?
Well, we certainly acknowledge in our papers, Your Honor, that Mr. Rizzuto's health is likely to decline in the future, but there was simply no evidence presented to the jury during the course of the trial that somehow Mr. Rizzuto was going to take a terrible turn for the worse and suffer much more significantly than the evidence they heard about his current condition. The plaintiff's experts estimated that his life expectancy was going to be another 16 years, which would take him to the natural life expectancy of a perfectly healthy white male. As a matter of fact, his own pulmonologist testified that Mr. Rizzuto's COPD was stable and that he was hopeful that barring any unforeseen change in his condition, Mr. Rizzuto would be in the same condition that he was at the trial 5 years down the road. That's the evidence that the jury heard. So for the jury to believe that or conclude that would be based solely on speculation and would be, I think, further evidence that the award itself is excessive.
But the jury heard it as a progressive degenerative disease, and he was going to get worse during the course of his remaining life expectancy.
But they heard no evidence to support the notion that he was going to suffer much more than what they had heard about his condition up to the point of trial. For example, Mr. Rizzuto, unlike the other cases that are cited by plaintiff, he was not on oxygen 24 hours a day. He engaged in all of his activities of daily living without the use of oxygen. He needed no assistance to walk. As a matter of fact, the jury heard that in the year prior to the trial, he was attending pulmonary rehabilitation sessions. He was exercising up to an hour per day without experiencing any significant shortness of breath. That was the uncontradicted evidence presented.
Wasn't there evidence as well that there was a diminution of his abilities? He couldn't walk as far, or couldn't walk his dogs, couldn't sing, I mean, things like that. There was evidence there that helps you and helps them, wasn't there?
Well, there's evidence that supports what Your Honor has just said, but it comes nowhere near to the cases like Caton, for example, where you had a woman who could not leave her home and was on oxygen 24 hours a day, and who frankly died shortly after the jury verdict and before the case went on appeal. Or like the Vernell Smith case, where Mr. Smith lost his lung and couldn't walk around the block, and he also died very shortly after the case was tried. There simply is no comparison to the evidence that the jury heard in this case about the limitations that Mr. Rizzuto had in comparison to the cases that plaintiff relies upon. And I will point out, we cite the Smith case. In Smith, the First District did approve a $10 million award for that particular smoker, but two justices concurred specially, saying that they thought that award was grossly excessive. One of the judges went so far as to say that it was conscience-shocking in his opinion, but they felt constrained by the Townsend case out of the First District Court of Appeal to simply affirm that award. However, this court is not constrained by any precedent in the Fifth District from overturning the award in this case as excessive. And frankly, ladies, Your Honors, Mr. Rizzuto's current limitations based upon the evidence that the jury heard, are relatively minor compared to those other COPD plaintiffs.
I mean, as a follow-up to Judge Maltz's question, the $10 million on the verdict form, there was no separation of past and future.
Correct.
So could the jury have appropriately, if you would compare the verdict, say in this case there's less in the past for pain and suffering, but there's going to be more in the future, as opposed to an individual who's further along in the COPD and closer to death, they may have more pain and suffering in the past, but less in the future?
Well, certainly we don't know exactly what was in the minds of the jury. None of us know the answer to that. But I don't think, based upon the evidence that the jury heard in this case, that a $10 million award could be supported by what might happen to Mr. Rizzuto in the future. That's completely speculative, based upon the record evidence in this case and the uncontradicted testimony of his own pulmonologist, who said, I think 5 years down the road, he's going to be in the same condition that he is today. That's the evidence that the jury heard in this case.
The jury awarded found no liability for punitive damages against
That's
your
right.
client. Doesn't that weigh against your argument that the jury was acting out of prejudice or passion against you?
No, I don't believe. As a matter of fact, I think the circumstances by which this jury occurred indicates that there was passion and prejudice. It was a 2-week trial. We closed in the morning on a Friday. The jury got the case at about 1:30 or 1:40 on Friday afternoon. They deliberated for about 6 to 7 hours. They returned the verdict at about 8:30 on a Friday night. One of the jurors had talked about having a vacation they wanted to go to the following week. I believe, Your Honor, that there is a punitive component to the non-economic damages award in this case. I think that's very clear, and that's a clear indication of passion and prejudice. And the fact that the jury simply doubled the amount that plaintiff's counsel asked for, again, I think, is another indicator that there was something amiss in what was going on with this jury and the verdict that they delivered.
I think there was a punitive element. Why wouldn't the jury have then just checked off yes for punitive damages and awarded something for punitive damages?
Well, because if they had checked yes to the punitive damages question, I should have said this earlier, they knew there would be a second phase of the case. It was a bifurcated trial, and they knew there might have been several additional days of evidence. I frankly think the jury said, well, let's just throw a punitive element into the compensatory award itself. But that is an indication, clear indication, that something other than the evidence to support compensatory damages drove the verdict and the amount that they awarded.
Let's talk about the comparative fault issue.
Sure, I wanted to get to that too. Thank you.
Before you get to that, you agree issue number 2 is resolved?
Yes, sir.
Okay.
The trial court also erred in failing to reduce the verdict by the percentage of fault the jury attributed to Mr. Rizzuto, which was 20%. The court can get to that result by 2 different methods. The first is one of statutory construction. We believe the court should conclude that the comparative fault statute, 768.81, applies to this case because the substance of the action sounds in negligence or products liability. Without getting into all the language of the statute very clearly says that, quote, the substance of an action, not conclusory terms used by a party, determines whether an action is a negligence action. And in this particular case, the substance of the plaintiff's case here was that Mr. Rizzuto developed COPD, chronic obstructive pulmonary disease, because he smoked a defective product. He smoked cigarettes, and because Philip Morris allegedly concealed information from him about the health risks of that product. So whether the plaintiff asserts claims for negligence or strict liability on the one hand, or fraud and conspiracy on the other, all of the claims, the substance of the action, all relates to the product, the harm that the product can cause, and allegedly a withholding of the information about that harm. So you can't get around the fact that at the end of the day, the case is all about the product. And for that reason, it is a negligence action and comparative fault, and the statute should apply. Now, this does involve an issue of statutory interpretation that so far has only been addressed by one other DCA, and that's the Surrey case out of the first. I think an easier way for the court to reach the same result is to conclude that based upon the way plaintiff tried this case, he's waived any argument that comparative fault does not apply. Simply put, you can't make statements to the jury to gain a strategic advantage and then run from the legal effect of those statements after you've obtained a favorable verdict. We believe that this court's four-line security case, in which the court held that where the jury was misled into believing that comparative fault would reduce the verdict and reversed for that reason, is applicable and is binding precedent in this case. We also believe that the Hyatt case out of the First District.
The trial court in its instructions tell the jury that if the jury finds a percentage of fault attributable to the plaintiff, that there would be a reduction on only some of the counts, not all of the counts, or something along those lines.
No, that's not what the court said. The plaintiff offered this instruction as sort of some quasi-middle ground, but the court instructed the jury that, quote, some claims are subject to reduction due to the fault of the claimant and others are not. The problem with this instruction was, number one, the trial judge never explained the concept of claims to the jury. The jury was never instructed what claims were being made. They didn't understand that. It might have meaning to us as lawyers, but it had absolutely no meaning to the jury. Secondly, immediately following the instruction that Your Honor has just referred to, the court then instructed the jury that in entering a judgment based on the jury's verdict, it, quote, will make any reduction required by law to reduce the total amount of damages by the percentage of fault which you find chargeable to plaintiff. That's essentially the standard instruction that's given in all cases where comparative fault applies. This is nearly the identical instruction that was given by the trial court in the Hyatt case, in which the First District held that the plaintiff's arguments to the jury combined with the court's instructions misled the jury into believing that there would be a reduction of the verdict. And so what happened here in this case is precisely what occurred in the Hyatt case. And if I could I'd just like the court to hear one of the statements. There were many statements made by plaintiff, but just one of the statements that plaintiff's counsel made to get a sense of what the jury was told. This is from the plaintiff's opening statement. He said, quote, you know, John Rizzuto accepts his fault and he wants a fair portion of the responsibility. We would be disingenuous to come in here and say it's all their fault, pointing to the defendants. That's not the case. It's shared. There is no doubt about it. The only question is what portion belongs on the tobacco companies. And that was the whole theme of his case. This is about shared responsibility. At no time did the plaintiff's counsel ever tell the jury, well, we're conceding fault with respect to negligence and strict liability, but we don't concede one whit of fault or responsibility with respect to either the fraud or the conspiracy claims. We were very concerned that this would be prejudicial to us, and so we asked the court, instruct the jury specifically that comparative fault will only apply to negligence and strict liability and will not apply to either of the intentional tort claims. The plaintiff objected to that, and the court refused our requested instruction. I even went so far as to say, Your Honor, well, you need to allow me in closing argument to explain that to the jury. Just let me tell the jury what the significance is of their findings on the two intentional tort claims. Let me tell them that if they answer yes to either one, comparative fault will not apply. The judge specifically ordered me that I was not allowed to do that, and then in closing argument, after the plaintiff had secured that ruling from the trial judge, the plaintiff went ahead and told the jury that there would be a reduction of fault and that Mr. Rizzuto was accepting responsibility in the case.
You've got about 2 minutes left for rebuttal time.
Okay. Well, let me save the rest of my time for rebuttal. Thank you.
Good morning. May it please the court. My name is Celine Humphreys, and I am here on behalf of the appellee, Mr. John Rizzuto. If you don't mind, I'm going to start with the issue that counsel was just addressing, and that's the apportionment argument. Yes, there are two aspects to the defendant's argument. There's their legal argument regarding what the statute addressing apportionment says and what it requires. I can tell you that every other DCA in this state has rejected that argument. In the Surrey decision, the first DCA expressly summarized and explained why it rejected that legal argument. I can also tell you as an officer of the court, the other DCAs have PCA'd in many other cases. There have been many appeals now in these Ingle progeny decisions in the other DCAs, many more than you've experienced of verdict appeals, and this argument has been PCA'd, including two of mine, one at the second DCA, that's the Schlenkler case, and one of mine at the third DCA, that's the Crawford case. On the factual argument they make, they have also not identified or persuaded any district court of appeal to reverse the trial court's discretionary ruling about waiver. Their very best case is the Hoyt case, or Hyatt, there's different pronunciations out of the first DCA. That case, Your Honors, was affirming a trial court's discretionary decision on waiver. Here, this case comes to you on a waiver decision. The trial court found no waiver. In fact, since...
Should we be concerned about the concept that a lawyer, suggests something to a jury and then doesn't, and so doing as the first language they use, curry favor, and then run away from it when the verdict comes in? Because it is good tactics, or could be good tactic, to say, look, we're responsible too. We're not putting all the blame here. In essence, my client's not seeking a windfall. My client is seeking a fair compensation for this, and implying that a fair compensation means that they're partially responsible as well. And then you get a verdict and say, no, we don't want any part of sharing responsibility. Should we be concerned about it? I know you're arguing discretionary call by the trial judge, but what if we have the exact two situations and one judge exercises discretion one way and one the other, and the facts are indistinguishable? Should we allow that?
Well, I make it a practice of being very careful to answer a judge's question directly, but I am going to actually break that out into two important points, if you don't mind. The first point is, when the only argument is made by the defendants that it is some comment by the plaintiff, is that enough as a matter of law to somehow invalidate the jury's thinking? Please look back at Surrey and Hoyt. Those are the only two written decisions, both from the First District Court of Appeal. There you have three circumstances happening. There's the question of whether or not the plaintiff's complaint, which here these plaintiffs affirmatively assert some level of fault. We explained it a little bit in our briefs. The reason is these defendants used to pull comparative fault last minute, inherently making this a contributory negligence case. When we first amended our complaints pursuant to Arnett's, which this court has recognized in the Bernard case, which I handled before this court, we alleged affirmatively comparative fault so we didn't get to the trial and be faced with a yes or no. Very soon after that, the defendant started saying, look at that language in your comparative fault. You just said we admit fault. And we all quickly scrambled and changed our complaint. So we say in the complaint, now this is a pleading. In the complaint we make clear we plead only comparative fault as to the two things the statute says it applies to, strict liability and negligence. We do not plead up comparative fault as to the intentional torts. So that aspect of Hoyt and Surrey that the courts looked at does not exist here. Also, what used to happen, in this litigation now, the trial started back in around 2007, 2008, and I started participating in 2009, so I've watched this evolve. What we used to do, as you know, as a former trial judge, or as a current trial judge, Judge Maltz, the plaintiff carries the burden in the jury instructions, and so we would follow the standard jury instructions. The standard jury instruction is different than what we have here, and I object to the comments made by opposing counsel. It was a hard fight for me to ask the trial court to deviate from the standards, because trial judges generally don't like to do that, and not tell the jury, I will apportion later, but instead tell the jury, I may if required by law. In, for example, their favorite case, Hoyt, the jury was given the standard. The jury was misled. And on top of that, you had the comment. So my first answer to you, Your Honor, is as a matter of law, when all you have is a comment by counsel.
Well, you have more than one comment. You have comments in opening, and you have comments in closing, and those are consistent comments.
Well, that was going to be my second point, but I'll go ahead and jump right now to that. I strongly disagree with how they've portrayed the comments by counsel to Hugh, and I ask that you look at those comments then if you are really concerned about us. My job at this trial, Your Honor, is legal support. I'm the person there making sure we have a clean trial. I'm the one making sure that there's no reason this...
Let me jump to one particular comment that really does...
Yes, sir.
There were many there where the shared responsibility was mentioned in the same breath, literally, as the conspiracy. And I'm looking now at page 3505, and plaintiff's trial counsel there is saying, you put the percentages down, the court handles the rest. You don't reduce the damages yourself. You don't take the numbers out and do the math yourself. The court does that. And the question is, are they ensnared? And the next thing that's done on that page is play the conspiracy video clip. And previously, it wasn't just the concealment, it was the entire conspiracy, it was the whole thing, it was the entire industry. So looking at number 4, we've told you already that Mr. Rizzuto accepts his fault. Trial counsel there is talking about everything, conspiracy, concealment, the defective product, all the rest of it, in one breath there, and then later on says, you don't have to do the math, you put the numbers down, the court will do the math. Not depending on what your answers are, the court will do the math, which, whether it's Friday afternoon or not, we've all had plenty of late Friday night verdicts, but, the jurors understand that there will be a reduction. How can you do that fairly and then later say, well, we're not really being as fair and, good guy as we told the jury 15 times. We really don't want to take any responsibility now.
I'm going to try to answer a little more directly. The reason I started with that history is in the context of a pleading, you say something, that frames the case. It is a yes or no. How did we plead our affirmative defense? Did we plead comparative fault as an intentional tort? When you're talking about information given to the jury and whether or not, it's not waiver anymore. It is, was the jury misled? And here, the trial court, based on knowing that, the defendants argued this well, and many comments that we cite to you on page 50, in closing argument before they go into that room and shut the door and consider, where the jury is very clearly made aware that this apportionment will not apply to all of the causes of action. This comment now about jury doesn't understand claims, what you were just referring to, of course they were talking about claims. We talk about the intentional torts, we talk about the product.
Oh, which claim would be apportioned and which claim would not, were they?
No, they were not, and they don't have to be. Again, remember, there's 2 ways that this issue can be looked at. One is legally pleading, your 4 corners, what your complaint says. That's a rigid, do you waive something, do you give something up, how have you pled a case? We're not there. Right now, we're on whether the trial court was wrong when it found this jury was not misled. This jury, the trial court specifically told them that whatever you do on apportionment, it's not going to apply to everything.
And right at the time you're talking about conspiracy, obviously an intentional tort, the same paragraph talking about sharing responsibility.
Well, let me go to that a little bit. I do want to say, the reason why I'm making the point I am, is if there are a couple comments in opening that are debatable one way or the other and are troubling you, we don't just look at that. We look at everything this jury heard and ask, were they misled? And what did they hear at the end before they went to deliberate? They heard unequivocally from the jury instructions by the judicial officer in the court, and then plaintiff repeated it in the record in volume 129, this is just some of the sites, page 25797, and in record volume 130, page 25835 to 36. Right before they went to deliberate, we want you to know that the apportionment of fault to him is not going to reduce all the damages. So this trial court had the whole trial. This trial court was there. This judge watched the evidence presented to the jury and heard all of the comments. And remember how far ahead that opening was, weeks ahead before the closing. And in his discretion, this trial judge found that this jury was not misled. And I will add to that, remember, the fundamental failing. So I'm right there talking about waiver and why you should defer to the trial court's determination, particularly since trial courts get broader discretion on the questions of waiver. There's also the legal point.
Let me ask you this, right up to the jury instructions, would a fair reading of the transcript reflect that there had been misleading?
No.
So you think even, because I'm trying to figure out if you're saying the jury instructions corrected a misleading, or whether you're saying there was no misleading at all?
I started to get to that, and then I went off on the point that I wanted to repeat, because I keep repeating, I think, that the easiest argument on waiver. I want to explain to you why those comments can happen. I understand a possible suspicion, looking at a cold record, seeing these comments pulled out of context and not reading the whole opening, or heck, more importantly, the whole closing, which really takes all the evidence that the jury heard. The fact of the matter is that these cases are also tried as, this is the story. What the defendants did in their product case, negligence and strict liability, is they intentionally designed these cigarettes to be more powerfully addictive so that people will smoke them more, bring the nicotine deep into their lungs, and get addicted quicker. And as part of that, they concealed it. So when you look at the plaintiff's comparative fault, when we're responding to the story, it is not just over here you had a concealment campaign, and over here you had an intentional bad design to promote people getting sick, getting addicted, and getting sick. It is part of the same story. So at times when we're telling the jury, here, welcome to the case, we're going to let you know what this story is, that is why at times it can be told as a unison. It is a very difficult burden for them, think of intentional, for them to say or prove to you that this is the case of a plaintiff intentionally trying to mislead the jury and curry favor. There's no evidence. If anything, if you really read through this record, this is a very clean trial where plaintiffs did not attempt to overreach on anything.
If you go to the two first DCA cases, in one case they found there had been a misleading aspect by plaintiff's counsel. The other they didn't. And they took out statements, that the plaintiff's counsel made to show that there had been no misleading. But then in the Hiot case, or however you pronounce it, they took out statements the plaintiff's counsel made which they suggested were misleading. So you can certainly try a case, as indicated by the plaintiff's counsel in Surrey, without making those type of statements, and still get the same information to the jury.
I would answer on that particular question 2 points. Please compare Hoyt, those comments, to the limited comments in opening here. And those comments in Hoyt were at closing, and they were much more powerful, number one. Number two...
Are you saying there are no comments in closing here?
No. Here, plaintiff went out of their way, with me whispering in plaintiff's ear, making sure, because this is an argument that's been... There's a couple appellate arguments that the defendants will start making over and over, so we become aware of them and make sure we avoid them.
Isn't page 3504, isn't that closing? And it wasn't just the concealment, it was the entire conspiracy. And, so looking at number 4, Mr. Rizzuto accepts his fault, that's closing argument, isn't it?
3504, I'm talking...
3504, is
Right.
that closing?
That's 4 digits. I'm citing to you closing, which is 5 digits. 25835 to 36. This was a tremendously long trial.
It's on the transcript page, that's 3504 is still opening, you're saying?
My understanding from their brief, from the comments that they cited, there were a couple comments they made now that did not make in their briefs. What I saw was from their opening. And even if, and again we're looking at, do we want to second guess this trial judge? Even if something could possibly be construed as bundling this somehow and creating error, this same plaintiff's attorney on his own affirmatively told the jury, your damages will not necessarily be apportioned depending on how you return.
But doesn't the verdict form also lead to the confusion, and I'm going to paraphrase the verdict form, but question 2 on the verdict form, was the concealment a legal cause of Mr. Rizzuto's injuries? Question 3, was the conspiracy to conceal a legal cause of Mr. Rizzuto's disease? And immediately thereafter, question 4, please state the percentage of any fault that was a legal cause of Mr. Rizzuto's disease, and boom, 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 with no indication that it only applies to certain counts and here and there.
Read the paragraph after that. That's one of the things I had to fight very hard for, Because remember, this is an argument that defendants are aware of being able to build in a case.
What paragraph are you alluding to?
There should be a paragraph regarding damages saying, do not adjust your damages according to apportionment, and if there is any reduction, this is where one of the places where we ask the court to deviate from the standards. If the law requires a reduction, and only if, then there will be a reduction. And I specifically asked for that to avoid this argument. But Judge Evander, I want to go back to your point, since you're troubled by Surrey. Remember what I said in the beginning. In Surrey,
Sorry.
well, you're troubled that this is like Surrey.
No, like here, I thought.
Oh, I'm sorry, you're right, Hoyt. You're troubled that this is like Hoyt, but both of them actually are the same point. In both cases, the First District was reviewing a trial court's determination. In both cases, particularly in Surrey, I'm saying the right case this time, the appellate court recognizes when it comes to waiver, we give incredibly broad discretion to the trial court. And in both cases, they were...
We do, but we also look at, if there's improper statements made during closing, and the trial judge grants the mistrial, there's certainly a legion of appellate court cases where there's reversal saying based on comments by defense counsel or based on comments by plaintiff's counsel that were clearly improper, we reverse. So, although the trial judge is entitled to discretion, it's not unfair.
I agree. But you know what? I didn't think of grabbing hold of that case law. You just made a great point. Trials are imperfect, especially when you have a trial that's in the range of 3 weeks. Mistakes are going to happen. So the court does not just look for, did you fumble and say something wrong in closing? You say, did it somehow invalidate the work of that jury? And there are plenty of cases where there are improper arguments in closing where no harm is found. How can there be harm here where, one, the comments were very limited in the scope of a 3-week trial, two, that same counsel also affirmatively told the jury, unequivocally looking at them and telling them, not all the damages won't be apportioned necessarily based on, reduced based on apportionment, told the jury, tried to cure any possible argument that could be made, and on top of that, we fought very hard and got...
Objection to either a jury instruction or permitting defense counsel to clarify for the jury, here's what will be reduced, here's what won't be reduced.
I had not heard that argument before today, and I wasn't going to call them out on that, but I was surprised to hear that argument. First of all, I am pretty darn certain, because I know this case really well, if you look into the record, I don't think you'll find that proposed written instruction, so they're the appellant, they've not preserved that, they can't show you that. And that argument that we want to go into details about negligence and strict liability, I don't remember them making that argument. I don't think they did, but I'm not prepared to answer that. But what I can tell you is the other reason why affirmance is proper here, not just because of a trial court's discretion, is fundamental to their argument is the belief that the jury would have acted improperly. So if they're right, implicit, they're believing the jury is going to return a different number depending on apportionment, that they're not going to follow the clear instructions of the law and not determine Mr. Rizzuto's pain and suffering based on clearly what they heard, but they're secretly going to come up with some other reason depending on apportionment. And you cannot premise an argument for reversal on an assumption that this jury is ignoring its job that it was instructed on. The only other point that I want to go to, I think that you all don't have any questions perhaps on the compensatory award, but I can't help but respond to one point. Instead of addressing the standard, the defendants assert, or the appellants here, assert 3 different arguments for remitting the compensatory. And if you listen to one of them, it's somehow we conceded that there was some error because of the economic award. And I can't help but repeat for you what I said in the brief, because I'm the one who did that supposed concession, and that is a misstatement. What we specifically did, well, it's a misstatement for 2 reasons. It ignores the fact, as I know you all know, the analysis on remitter of an economic award is very different than a non-economic award. The cases explain how much discretion we give to the jury in non-economic. In economic, as you're probably aware, there are more cases developing in the state, starting with the Truelove decision written by Justice Kennedy when he was at the 2nd, that turn it into an economic exercise. So I stood up to the trial judge and I said, we do not agree with them, but in an abundance of caution, this is a very clean trial. We don't want to do anything to get in the way of a PCA. We will let go of that $1.3 million, a significant sum. And that is why it was no concession of error by any stretch of the imagination. And the only other point that I wanted to remind the court is that on that issue, the argument is not just remittitor. If this court finds that the compensatory award is excessive and remands to the trial court, and that trial court returns anything more than the $1 million requested by defendants, they will assert, relying on a first district decision where they won this argument, that they get an automatic new trial. Despite being the movement, winning a remittitor, that they automatically get a new trial. So there's more at issue than issue 1 than just the remittitor argument. Thank you.
Thank you.
The issue, the reason I raise the economic damages award is because it shows, I think, more starkly than anything else in the record that the jury was not constrained by the evidence before them when they considered the issue of damages. There is no logical explanation for how this jury could have awarded twice the amount of economic damages sought by plaintiff's counsel and testified to by their experts without them going beyond the evidence. And that is a clue for this court that something was amiss with the award of damages in its entirety. I mean, you don't look at this one item and say, well, because they agreed to a remittitor, it doesn't demonstrate that something was wrong here. Clearly something was wrong. If affirmed, if this award is affirmed by the court, it would represent the highest amount awarded to a living Engel progeny plaintiff with COPD that has thus far been affirmed on appeal. Let me try to just answer a couple of the questions that your honors had about the comparative fault issue. Your Honor, Judge Edwards, you were reading from the closing argument, and it actually starts on the page prior. If you want to look at it, it's page 3504, where plaintiff again says, Mr. Rizzuto accepts fault. I stood up and objected. You'll see it in the record, because it was misleading to the jury without the caveat that not with respect to fraud or conspiracy. The objection was overruled, and then plaintiff's counsel made the statements that Your Honor read, where he clearly indicated that there would be a reduction in fault. And then he immediately starts talking about our intentional conduct. So when he asked the jury to essentially determine how much fault should go to the defendants, he cited our intentional conduct. That's further evidence that they've waived the issue. So, thank you very much.
We'll go ahead and be in recess for a short period of time, and we can join y'all in the lawyer's lounge there.